All right, good afternoon, everyone. This is Magistrate Acker. We are on the record on case 25 VR 260. This is the Alford Elder matter. We have the same appearances as before lunch. The petitioner is Mr. Austin Elder. The second named petitioner is Ms. Vicki Alford. And the respondent is Ms. Christiana Elder. All three parties appear. We broke for lunch, and parties had concluded their presentation of evidence prior to the lunch hour, and so we came back after lunch for oral ruling on Mr. Elder's motion. I'll let you all know over the lunch hour I did have an opportunity to review the House bills that Ms. Alford brought up, as well as the criminal cases that we've discussed on the record and that the court took judicial notice of. Those were Mr. Elder's criminal cases. Well, before I give you all my decision, is there anything else people want to say? You ready for me to make a decision? Okay, well, I'll start by saying that this case was opened at the conclusion of the dependency and neglect case involving Mr. Elder and Ms. Alford and the minor children, Apollo and Artemis Elder. That was case 23 JV 53. Judge Lawrence entered the allocation of parental responsibilities order, April 8th of 2025, and that was certified into this domestic relations case, 25 DR 260. Like we discussed during the hearing, the court ordered for Mr. Elder to have a minimum of 6 hours of unsupervised family time with the children per week, 1 overnight per week, and Mr. Elder's parenting time had the authority to be expanded or modified by agreement of he and Miss Christiana Elder without the need for court involvement. There was also a provision that addressed whether, if Miss Elder had concerns that Mr. Elder was using or abusing substances, that she could require a drug test prior to the beginning of any family time at his expense, and provisions for what would occur if the drug test was positive. Ms. Alford was also allocated parenting time, specifically professionally supervised, it says supervised family time 2 times per week at an agency that facilitates supervised family visitation, and that was to be at Ms. Alford's expense. Today's hearing is based on a motion filed by Mr. Elder asking to be allocated parental responsibilities for Artemis and Apollo. The court heard testimony during the hearing that the children have been placed with Mr. Elder since August of 2025, and that was by agreement of Mr. Elder and Miss Elder. Artemis is 3, and Apollo is 4. The children's birthdays are both coming up here shortly, so Apollo will soon be 5 and Artemis will soon be 4. The court heard testimony that the children have been doing well in father's care. He has, he does morning routines, gets the children up, makes breakfast for them, takes them to daycare. He runs a tight ship during the weekdays, and he has fun with the children on the weekends. He's had to take them to some medical appointments, and I think it was Apollo who recently had his tonsils removed. And there have been some other appointments or medical care that Mr. Elder has provided to the children, including an emergency visit overnight because Artemis had a croup cough, and Mr. Elder took care of that promptly. Mr. Elder is working at Carville Auto Mart. He has a home that he lives in with his girlfriend, and he pays rent. I do note he doesn't necessarily know the name of the person who owns the property, although he identified someone who can. He testified he pays $1,200 per month for the apartment. Mr. Elder has domestic violence cases, criminal cases that he was found guilty for in the past. I do note no criminal cases, no domestic violence cases have been filed since the conclusion of the dependency and neglect case. I looked at all of them and I did not find that there have been any new cases filed or any no new cases filed, which he's also not been charged with any domestic violence or any criminal acts since the conclusion of the dependency and neglect case in March of 2025. Mr. Elder also testified about the work he did. He was in jail for 7 months for the crimes that he committed. He went to community corrections, did rehabilitation treatment for 8 hours a day. He did IOP 5 days a week, then went down to 1 day a week of treatment. He also completed the fatherhood program and 28 domestic violence classes, which he paid for, and he paid his restitution. Mr. Elder believes he has essentially repaid his debt to society and atoned for his wrongs, and he stated over and over that his past does not define him and he's ready to move forward and really be the parent that he wants to be and that the children deserve. I do note that Miss Alford is the named victim in a number of the criminal cases. Miss Alford's position is that Mr. Elder has never apologized to her. Mr. Elder did apologize on the record. I don't find that Miss Alford was necessarily satisfied with that apology, and I'm just expressing that I took note that that was a dynamic between the parties. Miss Christiana Elder testified that she's the children's paternal grandmother. She was allocated parental responsibilities out of the dependency neglect case, and she agreed that Mr. Elder has had the children since August. She testified that Mr. Elder has been meeting all of the children's needs, doctor's appointments, daycare, school, and that the two of them have been co-parenting well, and she expressed that she has no concerns with the children living primarily or 100% of the time with father, and having Mr. Elder allocated parental responsibilities regarding the children and essentially allowing her to step back and be grandma rather than a primary custodian of the children. She says she still sees the children every 2 weeks, 3 to 4 hours, usually on Fridays. They do fun things like go for walks and have dinner. And Miss Elder expressed that Mr. Elder's changed, essentially. The court finally heard from Miss Alford. It's clear to the court that Miss Alford is, well, it's not even, I don't even need to say it's clear. Miss Alford objects to this modification, although I think Miss Alford objects to the children just essentially not being with her. It's my sense that Miss Alford really would like for the children to be with her, and she feels, and she's testified and expressed that she's been alienated from her children, and her concern is that that alienation will continue if the children live with Mr. Elder, and so I'm taking that into consideration. A lot of what Miss Alford really wants to talk about is how she can see her children and whether Mr. Elder is going to inhibit her ability to have a relationship with the children, and Mr. Elder testified he will follow court orders. The current court order for Miss Alford's parenting time is 2 visits a week, professionally supervised at her expense. Miss Alford expressed that she cannot see the children professionally supervised unless there's a dependency and neglect case. I'm going to address that in just a moment. But to the extent that the court is considering, well, that statutory provision which requires the court to consider whether the parties have the ability to encourage the sharing of love, affection, and contact between the child and the other party, except that if the court determines that a party is acting to protect the child from witnessing domestic violence or from being a victim of child abuse or neglect or domestic violence, the party's protective actions should not be considered with respect to this factor. The court is taking that into consideration. However, Mr. Elder's testimony that he is willing to follow court orders appears to be genuine, and it's not clear to me that there's even been an effort by Ms. Alford to arrange professionally supervised parenting time based on her belief that she is unable to do so. And so I can't find that that's something Mr. Elder is unwilling to cooperate with if Ms. Alford sets up the parenting time that she's been allocated by Judge Lawrence's order. Ms. Alford also, she's been a victim of domestic violence by Mr. Elder, and so she objects to joint decision-making, and the court is taking that into consideration. Well, 1410-124, subsection 2B, hang on, 1.5B, sorry, which requires the court to consider, or essentially, the court cannot allocate joint decision-making responsibilities between parties if there has been domestic violence unless there's credible evidence that the parties are able to work together to make decisions that are in the child's best interest. And so I'm taking that into consideration as well. And, well, looking at all of the best interest factors in 1410-124, 1.5a, you know, the thing that is most apparent to me is that Mr. Elder has stepped up and taken care of these children for 9 months now. There weren't any concerns brought to the court's attention that the children have lacked proper parental care or that their needs haven't been met, that they're not adjusted to Mr. Elder's home, school, or community, that really there's any, that the children are in some way negatively impacted by Mr. Elder's care. Really, all of the information that I received from the parties is that the transition has gone well, that Mr. Elder is rising to the occasion of caring for 2 small children, and that things are going well. I'm certainly aware of the dynamic between Mr. Elder and Ms. Alford, but that's not the issue for today's hearing, at least as far as Ms. Alford's parenting time is concerned. What I'm taking into consideration is the best interest of the children. And here, I do find that it's in the children's best interest to have parental rights allocated to Mr. Elder, given, well, there was a whole dependency neglect case. Ms. Alford was given a treatment plan by Judge Lawrence, and Judge Lawrence wrote in her order that Ms. Alford did not complete her treatment plan. The statement or the order specifically says that the treatment plan that was adopted for Ms. Alford is appropriate, and she has not successfully completed her treatment plan, nor has she addressed the issues that led to the Mesa County Department of Human Services involvement in this case. Conversely, Mr. Elder, Judge Lawrence found that he has complied with his treatment plan. And so the court finds that it's appropriate to allocate sole decision-making to Mr. Elder. Well, because he is going to be the sole caregiver for the children, Ms. Alford has professionally supervised parenting time, but given the relationship between the parties, I do not find that it's in the children's best interest to allocate joint decision-making, really because it's clear from this hearing that the parties are not able to make decisions jointly. There's just, I would be concerned that the children would, their needs would not be met if the parties needed to come to an agreement about any particular issue. That's 1410-124, 1.5b1, whether there's credible evidence of the ability of the parties to cooperate and to make decisions jointly. I cannot find that that's the case, and so I am allocating sole decision-making to Mr. Elder. I am also ordering that the children are to live with Mr. Elder. He is to be their primary and sole caregiver, and that Ms. Alford's parenting time, as ordered by the court, is to continue. I am also ordering that the parties are to communicate exclusively on talking parents and only about the children. If Mr. Elder makes a decision for the children, you need to let Ms. Alford know on talking parents, okay? So that she's kept in the loop. Ms. Alford brought up during the hearing that she wasn't informed of what was going on with her children, and I do find that she is entitled at least to be made aware of what's happening as far as major decisions, school changes, planned surgeries, having the tonsils taken out. That would be the type of major decision that Ms. Alford needs to be informed of on talking parents. Is that clear?
Yeah. Can I talk?
Well,
I'll just let you.
Let me just make sure I discussed everything that I wanted to. I did want to address the fact that there is domestic violence between the parties, and I am taking that into consideration when making this order. 1410-124 also requires the court to, well, take allegations of domestic violence, and if the court finds by a preponderance of the evidence that there has been domestic violence between the parties, into consideration. So 1410-124 subsection 4E states, when the court finds by a preponderance of the evidence that one of the parties has committed child abuse or neglect, domestic violence, or sexual assault resulting in the conception of a child, in formulating or approving a parenting plan, the court shall consider conditions on parenting time that ensure the safety of the child and the abused party, giving paramount consideration to the safety and the physical, mental, and emotional conditions and needs of the child and the abused party. In addition to any of the provisions set forth in subsection 7 of this section that are appropriate, the parenting plan in these cases may include, but is not limited to, an order limiting contact between the parties, which I do find that's appropriate. That's why I'm ordering that your communication is only to be on talking parents. That protects Ms. Alford, as well as ensures that your communication is appropriate and recorded. Anybody can bring the printout of the talking parents communication to court for the court to examine and determine if there's been violations of the order, and people need to be appropriate on there. And so I do find that that is necessary, well, based on lots of reasons, because of the dynamic between the parties, not the least of which is that there's been domestic violence where Mr. Elder was the perpetrator and Ms. Alford was the victim. The court also may consider other limiting or other provisions, such as having exchanges of the child or children occur in a protected setting, supervised parenting time, restrictions of overnight parenting time, or any other restrictions that the court deems are appropriate. I don't find that's necessary in this case. Mr. Elder has completed the treatment that was ordered for him to do by the court. He has not picked up any new domestic violence or violent charges, and he was found by Judge Lawrence to have successfully completed his treatment plan. And so I find that it's safe and appropriate for the children to live with Mr. Elder and for him to be the primary caregiver, despite the fact that he has perpetrated domestic violence. So I've taken into consideration what the statute requires of me, given that that is a factor that is at play between the parties, and I still find that it is in the children's best interest to for Mr. Elder to be allocated sole decision-making and all parenting time, except for the time that Ms. Alford will spend with the children when she has her visits. Let me just say one more thing, and then I want to hear from you all. Ms. Alford, regarding whether you're allowed to have professionally supervised visits without a dependency neglect case, that's not accurate. You can pay for professionally supervised visits. Hilltop does professionally supervised visits. They have limited availability, and it's not free, but it exists. And so, have you contacted Hilltop in the past?
Hilltop denied my request outright because that's where Austin's girlfriend works. So I don't know if that has anything to do with why they denied it, but they outright denied it. So I don't know of any other facilities.
All right, Mr. Elder, what do you know about?
She doesn't work there anymore.
All right, we'll try again then, okay? Do you want me to give you the phone number?
I'm not sure if that's why they denied it. I correlated those two facts. I'm not sure. They didn't give a reason as to why they denied it. And
when did you last reach out?
January
of 2026.
Mm-hmm.
When did your significant other stop working there?
Sometime last year, I think.
All right, well.
So then it's not related.
As far as I'm aware, before Christmas.
Did they tell you, no, we're not going to supervise your visits, or did they say we're full and we just don't have availability at this time? What did they tell you?
They didn't give an explanation.
How did they communicate this to you, on the phone or
on the phone?
In writing?
Mm-hmm. Yeah, and I think it also is because the chief the CPO, the chief people officer, is my aunt. So there's like all these conflicts of interest that are just floating around, and like I don't know if DHS had something to do with it. I've never had any issues with Hilltop personally, but I was just trying to figure out why they would just say, oh well, your request is denied. They said that they can't accept private payment. So if they lied to me, then I mean I can't say what the real reason was, but
Well, I can guarantee you Hilltop does private pay visitation supervision. That's something the court orders regularly if there's child safety concerns. and that happens on private domestic relations cases where the department is not involved and people have to pay for it on their own.
so
So I'm just letting you know, here's what I'm gonna say. I want you to contact them again.
Mhm.
Okay? Try again. It's Friday afternoon. Maybe wait till Monday
Mhm.
and contact them again because you are entitled to parenting time and that needs to happen.
Right.
And Mr. Elder, you need to, if Miss Alford gets in touch with Hilltop and they reach out to you to set up, it's probably gonna be an intake to meet you, give you expectations and schedule the parenting time, you need to follow up. If Miss Alford filed a motion and said, I've been trying, but he won't ever get back to them, it's been X amount of time, they've called him 3 times, he doesn't get back to them, that could be grounds for a parenting time disputes motion, and we'd be back here, and the court would be taking testimony about whether people have violated the parenting plan. So I'm giving you that warning, you need to follow up if someone reaches out to you. And Miss Alford, if you hear from Hilltop that they can get you in, you need to communicate that to Mr. Elder on Talking Parents, so that it's all recorded and you all can bring that to court and say, look, I reached out on this day, here's what they responded, they never read my message, they never followed up, or here's how they responded, and the court can determine what's really going on. I want you to know that this is not us, this is you copying and then pasting the messages. It's not the same as a printout. There's authenticating codes on the Talking Parents record. It might cost money to download the record,
$100,
which is a barrier, and I absolutely understand that. But that's what needs to happen if you want the court to read what you all are discussing on Talking Parents. That's the point of it.
Okay, if we stipulate to it being a true and accurate representation of the conversation, wouldn't suffice?
I suppose we didn't get that far because you didn't ask to admit it,
Mhm.
but I'm telling you that what the court is used to seeing is the printout. And I acknowledge it's a cost, and I wish I could have the state of Colorado pay for that. I wish I could have the state of Colorado pay for everything. It's just not the reality of the situation on these private cases where the issue is custody and the Department of Human Services isn't involved.
Okay, I have 2 things.
Sure.
One, there's another House bill. I can't remember the exact statute, but it said that parenting time needs to be in the least restrictive setting, like kinship, like family supervision, if supervision is even necessary at all, is preferred to a facility. I think a facility is, in my opinion, just a way to keep me financially barred from being able to see my children on top of everything else. And it is a law now that, like, unless there's a specific articulable danger to the children that can be identified and articulated on the record as to why supervision is the only possible setting where parenting time can occur, then it needs to be, in the least restrictive setting, like at my dad's house, for example.
Well, you can file a motion. That's not what we're here to address today, like I mentioned.
I did. I just, if I file another motion, I guess I will file another motion. I just hope that it's not suppressed again. I'm going to go pick up my register of actions to figure out which things were suppressed because I don't know anything anymore. So I will file a motion as soon as I can get it put
And reach
together.
out to Hilltop in the meantime, okay? Because every day you miss of your children's lives is a day you can't get back, and they're getting another year older, and it's going to be harder and harder to reintroduce and get to know them. You haven't seen them in a year, which truly breaks my heart. Is there anything else you wanted to say, ma'am? All right, Mr. Elder, do you have any questions for me?
Yeah, so the Talking Parents app, how do I set that up? How does it get set up?
You need to open your phone, go to the App Store, Google search Talking Parents, and then download the app. and set up an account. I'm not usually in this courtroom, so I don't know. I think you can find information online really easily. I give you a flyer. It's in my old courtroom. But you all need to find each other on Talking Parents. I think if Miss Elder was communicating with Miss Elder at Talking Parents, maybe can you show him how to do it, Miss Elder?
Yes, I can.
Okay, great. So that's, and then there is a cost. I think there used to be a free version. Now the cheapest version is like $7 a month. So there are more expensive versions and you get more features, but you at least need to get the base version, okay? Before I come to you, Miss Elder, is there anything else you wanted to say, Mr. Elder?
Not at this time.
Okay. Or do you have any questions for me, sir?
I don't think anything that I can address in this hearing. I think there's some things that will be addressed in a different hearing.
Okay. I appreciate that. I understand. This is not like
Yeah,
a settled situation, but really we were here on the issue of reallocating APR to Mr. Elder. So we can come back another day to discuss Miss Alfred's parenting time if that's what you were gonna address, sir.
Yeah, there's just.
Well, here's what I'll say. Ms. Alfred can file a motion, and then you'll get 21 days to file a response. And then the court, Ms. Alfred can file a reply. You have 7 days to file a reply. You don't have to. And the court will set a hearing. And so, what I'll say is you all need to serve each other. If you file a motion, you need to serve it. If you file exhibits, you need to serve the exhibits, not just the exhibit list. Anything you want the court to look at, you need to share with each other. And so you will know if something's been filed because that's going to be, you'll serve that upon one another. And then you can count 21 days from the day that the motion was filed to when you need to have a response filed.
And mail still works this serving.
You all can opt in to e-service if you want to. That's free to do downstairs, but you don't have to. Just then you would receive pleadings to your email rather than to your mail. It's up to you. Anything else?
It's fine. I think I can follow the court orders.
Okay. Ms. Elder, you wanted to say something?
I'm okay. I apologize. Thank you.
Sure.
Yes.
All right, Ms. Alfred, is there anything else you want to say or ask? All right. Well, that's everything that the court needed to address for today. And future motions are filed and the court will take those up, okay? I'll put that in writing. I think it's apparent, I don't know, that we had some changes in judicial officers, so I've got a little bit of a backlog. I will get it out as soon as I can. Okay? I will issue a minute order today, and I'm gonna sign it so that the order is effective today, and if you want to say with Ms. Alford, well, I will issue a written order. If you want to appeal the minute order, I suppose you could do that. It might make more sense to wait until after the written order comes out, so the findings are in there. But the order is effective as of today. Okay, and you'll get the signed minute order in the mail, that'll go out. And then I'll issue an order that's a little bit more expansive and explains, my reasoning, okay?
And just to be clear, so it's basically the same thing that was allocated to Shannon Elder, was allocated to me,
Yep.
so like, she can't just show up to the school, but
The order is, nothing has changed except for parental responsibilities that were allocated to Miss Elder have been allocated to you, Mr. Elder.
a lot of the things that were referenced in the first, I think in the first one, just in that.
Yes, well, this is just a slight modification. Anything else in Judge Lawrence's order, remains in full force and effect. So this is just the one modification, plus the order for you to communicate on Talking Parents and for you to notify Ms. Elder of major decisions that you're making.
Well, yeah, I just foresee this being, we're gonna have to continue to have court hearings. I just wanna make sure that some of the things that stand stood before stand still. With like our parenting plans and how we, we're good. I think those answered my questions.
Okay, all right. Well, that'll be the end of today's hearing. You'll get